Good evening, everyone. I, Yash Mittal, on the behalf of Internship and Placement Committee of Dr. Ram Manohar Lohia, National Law University, welcome you all to the second day of three-day certificate course on fashion and intellectual property right law by Ms. Namrata Pahwa. We welcome you, ma'am. Today, ma'am will be discussing on patent law and allied topics. Along with it, she'll be discussing certain important case laws regarding it. So, going straight to the session, ma'am, we can start with the session.
Absolutely. Thank you, Yash.
Thank you, ma'am.
Um, Welcome back to everybody who is in day two for this course. Thank you for joining in again. So before we go on forth, let's do a quick recap of what we did yesterday. All right. So yesterday we did first and foremost, of course, what is fashion law. Fashion law is an amalgamation of various different facets of law, namely intellectual property, contracts, labor laws, company, customs, and various others. It's an umbrella term which houses all of them. Now, what we discussed was that we started off discussing the first and most important facet, which was intellectual property. Now, IP again is or can be bifurcated within three verticals. First is prosecution, which means filing. Second is transactional, which means contract drafting and vetting, which we'll discuss tomorrow. And third is litigation, which means for dispute resolution, again, which we'll discuss tomorrow. So today, what I want to do is to focus on the IP aspect. Yesterday, we finished discussing trademark. So a trademark can be any word, phrase, a device, mark, logo, which represents your business or your goods and services and differentiates it from somebody else's goods and services. Right? We talked about different case laws and then we went on to copyright. Now, copyright, like we discussed yesterday, is subsists in any original literary, dramatic, musical, artistic work. It also falls for software. Um, there are different kinds or exceptions for copyright, and of course, the most important remuneration that you would get out of copyright is a royalty. Now, let's go on to a few case laws. Can we have the next slide? Yeah, thank you. So we'll be discussing two or three important case laws here, which actually has important meaning and has a great precedence over the way the future case laws would deal with. First is tips versus wing, right? What happened here is basically, sorry, 1 second. Right. So Tips Industries, as we all know, is a great music production house, found that the telecom giant Wink was guilty of direct infringement of copyrights of the plaintiff. Tips Industries, of course, is the owner of over, say, 25,000 sound recordings, and it had licensed Wink to use its music for its online streaming and downloads. After the expiry of the license period, no negotiations were reached between both the parties and to further extend it. And even after the notice was given from Tips to Wing to remove the sound recordings from its portal, Wing still kept on using the sound recordings. Of course, Wing said that or invoked 31D of the Copyright Act, claiming that they are a broadcasting organization and are entitled to a statutory license under the section, or because they are communicating the work to the public. Now, these phrases that I'm using, communicating to the work, to the public, broadcasting societies, please make note of them because you will find these in a lot of precedents. Now, what happened was, so according to Section 31D of the Copyright Act, it provides for a statutory license scheme for any broadcasting organization desirous of communicating to the public any sound recording. So, Unfortunately, Wink was still under the assumption that it had the uh, said license, but TIPS had immense evidence to show that the license period had been elapsed and there was no repeat license for the same. So, of course, it did had to stop, in fact, using the sound recording. So, what we get out of this is even though you feel that you're a broadcasting unit, um, Wink was not broadcasting it to the public per se. It was, in fact, selling those particular sound recordings. So it was constituted as a sale and not for general use of the public. So these are the few differences when you have to think of when you think of a license agreement or a broadcasting agreement per se. So next, we go on to University of Oxford versus Rameshwari photocopy services, also popularly known as the DU photocopy case. This I don't think I need to tell you, but this was a clear copyright license happening in Delhi University, where this also falls under the exceptions to copyright, which we spoke about earlier, that how for education purposes certain parts of a book can be photocopied and that will not constitute as a copyright infringement. Now, University of Oxford stated that this particular gentleman's shop fell outside the boundaries of DU, and only DU had that right. But of course, DU backed up this store owner and said that no, it is part of our university as a whole. So thankfully, he it did not constitute as a copyright infringement. Now, moving on to the last case that I would discuss in the copyright matter, it is actually can be seen in both copyright and design. This is probably one very popular case where copyright law and design law sort of have an amalgamation or a midpoint. Here we see that. Sorry, one second. Right. Here we see that Ritika Private Limited, also popularly known as Ritu Kumar, had sued Biba, which is also a garment house or a store, like we can say. So basically, in this case, Ritu Kumar had copyrighted certain elements of a design, right? Now, under Section 52 of the Copyright Act, if you are copywriting up or if you are reproducing an article over 50 times and selling it to the end consumer through industrial process, then after the 50th time of the reproduction, you subsist to have a copyright protection in that particular article, and it goes on to the design domain. Now, unfortunately for Ritu Kumar, obviously it's a big design house, and it definitely made more than 50 copies of its garment, or actually of its protected element on the garment. Um, and unfortunately for her, although she did have a copyright, she did not have a design application on the particular element. So after the 50th reproduction, she lost her copyright application and went to the design domain, where Biba was inspired and then took on that element on their goods. So here, in fact, there was no copyright infringement seen because Ritu Kumar wasn't legally sound when it came to a copyright and design acts. Can we go on to the next slide? Okay, so now we come to probably the most technical part of the IP domain that we see is the patent. Now, a patent, as mentioned in the statute, is an exclusive right granted to an invention. Now, can we go to the next slide quickly? Right. So these are the three important things that you would require in your patent for it to hold in the court of law. It has to be novel, it has to be new, it has to be capable of industrial application, and of course, it has to have an inventive step. So now, what do we mean about all these things? Now, suppose you have a washing machine, right? A washing machine can have is a standard essential patent. We'll talk about that later. It's say it's a two cycle washing machine, right? Now you as an inventor are trying to invent something new when it comes to the washing machine. You put in something which is new, a new element to the already established washing machine. It has to be used in industrial application, means when you use it, it has to be used capably. And of course, what you're the way you're putting it or the way you're inventing it has to have a new step involved. So it just can't be that I'm just replacing the old one with a new sheet or a new cover on top, or it doesn't work that way. Let's quickly go back to the previous slide. So yeah, so after 20 years, it's not like trademark that you hopefully can renew. After 20 years, your patent does expire and it goes on into the public domain. So usually, what we as lawyers suggest to our clients is today you're an inventor and you've created your invention, you've patented it, and tomorrow you may think of a new step that you feel like, oh my god, I should have included that or incorporated that in my patent claims, right? So in you can amend your patent claim and you can put it again, but it's just going to be it's not going to be cost effective. So what we prescribe is that you keep on re-evaluating your patent, and for every new invention or every new step that you think of, you should file a new patent entirely. Which is why actually, say all production houses, all big pharma companies, they have hundreds of thousand patent applications per year, is because they keep inventing, they keep rolling out things, and they keep filing it so that they want protection on it entirely. Another thing which is meant for mostly lean startups or people who don't want to invest entirely is something called provisional patent application and a utility patent application. By which I mean is there are two ways of filing it. One is that today, so say you have a patent that you want to file, you file a provisional application where you state your claim, basic claims, and it's a more brief version of your patent application. And thereafter, you have 12 months within which you can file your final or utility patent application. So those 12 months also gives you the time if you want to amend it, if you want to add, subtract, or do whatever you want with it. And of course, it breaks the cost bracket into half. Can you have the next slide? And the next. So yeah, let's look at how patent is useful in the fashion world. You will be so surprised because patent is so useful in the fashion industry, and there are so many things that we wear, we put on, we see in the market, which may or may not be. We wouldn't think that, oh my god, there isn't technology involved in this, or it's not really patentable, but it is. And there are certain examples which all of us may have worn, something like stonewashed jeans, right? So, how is a stonewashed jean actually stonewashed? It's basically a chemical applied on the denim, and through an industrial application, it's the way it moves on the denim and the way it applies, that is patented. Then something like lingerie is actually heavily patented. We talk about a case later, but your wonder bras, your spanks, something which sort of holds your body together, those frames are patented. Also, very famous example is material. So created by, in fact, Buckwheeler, when the material which controls body odor. There are materials which make your body cooler. So these kind of fabrics that are innovative, that have a new technology in them, are all patentable. Can we go to the next slide? Right. So now let's look at the other two cases are not there. Okay, anyway. So we will discuss two cases amongst them. One case which isn't mentioned here is, excuse me, Spanx versus Yummy Tummy. So it's a very recent case, about I think a year and a half, 2 years ago. Uh, so we spoke about how lingerie plays a huge role in the patent world, right? So Spanx versus Yummy Tummy. Spanx and Yummy Tummy are both lingerie or innerwear brands that make your body fitted and more formatted, and they create innerwear which uh, make your body that way. So what happened was that both Spanx and Yummy Tummy had created tank tops which similar patent claims, very similar looking, and also filed it at the very similar time. So they both were very against the other, that you're infringing my claim or you're infringing my claim. But it turned out that they did have a similar idea and they did file it in the same time. That is why instead of going to court, they decided to go settle the matter out of court for a rather large sum. And actually, we'll discuss how arbitration, more than litigation as well, plays a huge role in the fashion world, and we'll discuss it tomorrow in the dispute resolution time. But when you have a patent, right, you don't want it litigated in court. You don't want the claims to be elaborated in court, because then it will be in the public domain. So, in such times when the matter is confidential in nature, where you don't want public display, then you would go to arbitration. So, in fact, the arbitration laws of the world are so evolved that there are so many centers where you can approach and actually have a good solution out of it. Um, okay, let's look at from here. Let's look at Phillips versus Rajesh Bansal. Now, like we spoke about, standard essential patent. This case was India's first standard essential patent case, which I had the great honor to be a part of. I was defending the matter. Um, Now, what happened was, okay, let me explain what a standard essential patent is, right? So there are a few patents in the country, like your television, your laptop, your washing machine, and in this case, it was a DVD player. So Philips has such essential patent granted by the government, and now such patents, what happens, because it's for general and mass use, the government picks out these patents, and for FRAND terms. Now it's FRAND means reasonable and non-discriminatory terms. Now, in for these terms, which is also a license, for these license in terms, these companies can license their patent out to somebody else. Now, here what happened was, Philips actually offered two types of patent licenses to DVD video manufacturers. One was a Philips only patent, and one was a like a joint version patent, which had Philips, Sony, LG, amongst others. Um, Now, what happened was, even though Philips claimed to have invented the DVD player, it was actually a decoder. So the DVD player houses a decoder in which there is a chip which actually records everything, which is the foremost important part of a DVD Yeah. Now Philips does and did license out its SEP to everybody else, so whoever needed it in the market. And Rajesh Bansal, on the other hand, was a manufacturer. He assembled and then sold. He assembled the parts from various other sources, legitimate sources, and he thereafter sold them in the market. Rajesh Bansal was under the assumption that the sources that he's getting these licenses from are actually valid licenses from Philips itself, but they weren't. And Philips was actually able to show with great evidence that there was no license amongst or between Rajesh Bansal and Philips directly. So unfortunately, also Rajesh Bansal could not. One of the biggest arguments that he made was that a DVD player is a big unit, right? So you cannot have a patent on the entire structure. But Philips actually proved with good evidence that it held the uh, license on that particular chip, like I told you before, which actually Rajesh Bansal was using to resell. So that is why Philips sued Rajesh Bansal, and unfortunately, after a long, long period and an exhaustive final argument session, Rajesh Bansal had to um, pay Philips, I think, a sum of damages for 5 lakhs and of course so many other things. So, patent actually, this entire thing tells us that how licensing, having the correct licenses, knowing where to get your licenses from, um, updating a patent, uh, using a patent wisely, not infringing it. Such things are so important, even beyond the invention and the application. So your job doesn't just stop there. So these are the things that you need to keep in mind. Can we go to the next slide? Right. So let's come to design. Um, Design is actually again an incredibly important part of the fashion world, but it is the decorative and non-functional feature of, say, a product, right? So its shape, its pattern, its configuration of lines, composition, or any part or any element of the design which is in three dimension or both. Now, unfortunately, design is only valid for 15 years and thereafter it goes on in the public domain. Can we have the next slide? Right. So, this is probably the most popular design element that there is in the world actually, and you can see the different variations and the different applications that Coca-Cola itself had filed for its very unique design bottle. So a great practical tip that I could give you is that, say, you want to file, you have a client who comes and says that I want to file a design application for my bag, right? Now, how will you file a three-dimensional figure and how will you upload it? How will you file it in physical or either way? So you will take pictures of all the verticals, say front, back, sides. You will get it together and then file it. So that is a huge tip for practicing lawyers there. That it's just not that you can't file this if I print this particular picture out, you can't file this and send it this way. Can we have the next slide? So yeah, so in the fashion world, like you would see, uh, so there are lots of bags, there are lots of shoes, there are lots of belts that there are which are ornamentational and it has 3D effect like the Celine bag or the Christian Louboutin boots. These are extremely important, extremely popular design applications because of the way they're made, because of the way they're composed or formulated. Next slide, please. Right. So let's look at a couple of cases from the design domain. So, what should we look at first? Okay, let's look at Crocs versus Liberty. This is actually quite a popular case because Crocs, as we all know, is a very unique form of footwear, very popularly known worldwide. It actually has design applications for his, those perforated and clog type slippers, shoes that we have. It was for that. Now, what happened was the court in this case, the evidence placed before it accepted that the case existed in favor of the defendant, which is Liberty. Since the design, similar to that of the design of the Crocs, had already been published in the public domain prior to it filing it. So the design that Crocs had filed was already in the public domain, and therefore Liberty shoes was actually inspired by the correct thing, and Crocs was actually not the exclusive registered uh, design authority to have that particular protection. Um, which is again to say that it is extremely important not to have your or not to publish your designs in the public domain prior to protecting it. Now let's look at Good Earth versus Krishna Mehta, or otherwise known as Good Earth versus India Circus. In this case, what happened was, um, Good Earth is actually, like we all know, is a very popular brand for mugs and crockery and clothes and bed covers and things. Now, what happened was that Krishna Mehta was actually an ex-employee of Good Earth, and soon after he left Good Earth, he started India Circus. Now, Good Earth already had a couple of designs, particularly the motifs and the logos. Like the lotus motif or the barley mint, the rose princesses on the products. It already had design applications on them. Um, and of course, Krishna Mehta was had gotten inspired by the same and started infringing the same on by putting it on its goods and services. Now, thankfully, so the court discussed that it was a passing of matter because the concept of novelty lied with good earth. So Krishna Mehta had actually said that no, these logos and motifs are actually it's culturally known and it's not novel to good earth. It's not exclusive to good earth. But thankfully, Good Earth was actually able to prove with great evidence that it is exclusive to them, and they had been using it for many decades. And Krishna Mehta is actually not allowed to be infringing the same. So even though in the fashion world there is great concept of being inspired. So where do we draw the line? Where is that line where today you can be inspired by, say, an international artist and you're a designer, and where will you? Where is the balance where you reach that you can still be authentic uh, and an original creator, but at the same time you will not be infringing your the other person's creation. So that thin line is where we need more clarity on from the statutes. Although through precedents we have seen through the years that more often than not we are able to decide which is the original creator and who is not. Can we go on to the next slide? Okay, so actually, I want to discuss one more case which I have in my notes is that the case of Crocs versus Aqualite. So in this case, what happened was this. like we previously discussed, Ritika versus Biba, which was crossover between copyright and design, right? This case is actually a crossover between design and trademark. Now, what happened in this case was that the plaintiff, which is Crocs again, instituted a case on the defendant's alleged copying of its shape trademark. So, what Crocs had done is it had filed a composite suit for its particular design and for its trade dress and trademark. Now, the plaintiff had initially filed separate suit, but later on combined it to one composite suit for passing off an infringement. So, when the court actually adjudged that the matter was not one of infringement, Crocs came back to say that no, but even if it's not for infringement, I still have a passing off validation which you can look over. But the issue arose as to filing of the composite suit against various footwear companies, right? So the court actually, through examining the provisions of the Design Act and the Trademarks Act, held that the composite suit for design infringement and passing off is maintainable on account of common questions of law and facts between two causes of actions to avoid multiplicity. However, it stated that the registered design cannot constitute a trademark. And the intention of the legislation is actually clear that if you see the statutory definition of a design, it says that composition of lines, etc., which is not a trademark. So tomorrow you cannot get up and say that okay, if it's not a design application, at least I'll file it as a trademark and get my passing off vindication. But it doesn't work like that. So the features of design, say such as shape, configuration, pattern, even if it is used as a trademark, ceases to be a trademark once there is a design application on it. So the court actually concluded that Crocs had failed to show any extra feature beyond the registered design which can be protected in passing of actions. Um, these features could have been like an extra layer or any feature which additional to their original design application. This is actually a very interesting case because it's significant to its broader impact. One aspect is whether the trademark office will be more mindful in examining these overlap matters or not. So this is a very interesting case. It's actually very recent, so you can have it to read, and we can discuss it tomorrow in detail if you wish, because there are certain technical elements like a composite suit, the legislation, the crossover, and everything. So let me know if you want to discuss this case in detail tomorrow. Let's go on to the next slide. Okay. So, before we get on to wearable tech again, I want to quickly just briefly go through what a GI is, because yesterday we had questions regarding it, and although I hadn't included it in the PPT, but it's of course it's always best to know. So, um, in quick time, we'll discuss what GI is. So, GI tags are awarded to any goods which are originated and attributed to a particular location, right? Say like rasgullas or Banarsi saris or chanderi. So these are originated to a particular location, and it shows the cultural aspect of that particular location, and only then a GI tag is given to that place or that particular product. Um, how GI is affecting the local artisans is actually in a great way, positively, and I would say negatively as well. Positively, how um, it's first generating a lot of know-how, a lot of awareness amongst the market, which in turn is generating livelihood. It is generating jobs for the local artisans, and that is the probably the sole way where they're getting back from the government in forms of royalty or remuneration in some way. Um, Maybe a negative way that I can think of is because uh, there's so much knowledge and there's so much awareness and popularity. The prices of the good slightly increases, and the middlemen who deal with these have drastic profit points to look into. So, and in fact, the original seller or the local artisan just still gets peanuts, while the end seller is making a lot of profit. But actually, the government is taking great initiatives. The lot of trade fairs, a lot of events, the lot of promotional things that they're doing to create awareness, to make people know their cultural heritage and to popularize them in a way that the local artisans get more. Uh, they're more in the market right now more than ever actually. And there's a really funny case which is very recent again, is the Rasgulla case. So I'm actually from originally from Calcutta, so this is sort of a thing that I would always resonate with. It's Bangla Rasgulla or Orissa Rasgulla, right? So these are the two facets. So what happened here was, uh, even I was actually under the assumption that the Roshogulla is originated from Bengal, West Bengal itself, and that's why it's valid to have the GI tag of Bangla Roshogulla. But Orissa said that no, it was originated here, and we should have the tag, which is actually this matter is yet to be adjudicated, and there's still sort of a gray area as to where the this popular good was created from. Right. So now let's go on to wearable tech. Yeah, thank you. Now, wearable technology is probably the most relevant in today's day and age. We all have known or seen or own something wearable tech. Now, what is wearable technology? Um, Clearly explained is, say, if any technology that is touching your skin and you're wearing it day in and day out is wearable technology. So anything from your smartphones, Fitbits, headgears, mountable devices. Nowadays, there's a built-in chip. So all of those things are wearable tech. Again, wearable technology is actually a very important part of fashion world, because you will see now that there are a lot of technology involved in the kind of garments are produced in the international market, at least. Um, but unfortunately, there is again a bifurcated way of protecting it. Again, there is no umbrella term or umbrella way where you can just say this is my new invented product line and I want to protect it. You will have to bifurcate it in, say your brand name can be trademarked, your the element can be protected under the copyright, your design can be protected under Designs Act, the technology that you create can be protected under patent, and so on and so forth. So you will have to bifurcate your line and then protect it under different statutes. um, the three main things that you will need to focus on when it comes to wearable tech, and something which is of again of great importance today, which is data. Now, as we all know or heard, have seen, that data is the new oil, right? And why do we say that? Because we're all on our phones day in day out, on our laptops, on our tabs, and everything that we're saying or doing or talking is everything is being documented. And say suppose more so for wearable tech, right? Because if you have it on your body at all times, it must be accumulating so much data of, say, the consumer, that there has to be a way of utilizing it or keeping the privacy in check. So the three things that you need to think about is, first is invention rights. Your invention, of course, must be novel and original to you. Second is data rights. How, as you say, you're the original creator. How are you making sure that me, the consumer's rights are protected. Say the data is protected, and I don't feel like violated in some sort. And of course, then there are product rights. How are you protecting this particular invention and this garment in the market? So these are the three things that you need to think about while creating wearable tech and then of course selling it in the market. And we go on to the next slide. Right. So the last part of today's session is where we talk about trade secret and confidential information. This is something which is very controversial in the legal industry because, unfortunately, in India, there isn't any statute under which we can protect trade secrets or confidential information. It can only be protected under the clauses of a contract, which is why when I say contract drafting and vetting is just not, those basic clauses that you see, indemnity and consent and termination and so on and so forth. There's so much more that you need to think of when it comes to contract drafting, vetting. Um, Trade secret and confidential information can be any formula, any business aspect information that you want to protect as your own, exclusive to you, and maintain an advantage over and above your competitors. So it's extremely important to protect it and not let it leak out there. So when it comes to trade secret confidential information, another important content that I can think of is like, say, your service provider contracts or your employee employer contracts. If you'll ever notice them, it'll always have a confidential information clause or say some sort of a clause which will prohibit your either the employee or the service provider or the vendor or whoever you're collaborating with, prohibit them from leaking out your said trade secret to the world. So I guess we should stop here for today and we can get questions. And tomorrow we will talk about uh, negotiations. We will talk about some more about fashion negotiations. We will discuss important clauses. We will discuss how supply chain matters, and of course, in the end, we'll discuss arbitration and litigation and the ways where we can control the disputes and, of course, get as much as damages as you can if there is a dispute at the end of the day. So, Yash, let's take questions for today.
Fashion related intellectual property litigation concerning social media and e commerce on the rise.
Cannot hear you. Shruti, yes. IP litigation, especially in the right now in the social media age, is on the rise. And in fact, there is a very important case law which I can just briefly tell you is the FTC versus TME LLC. So in this case, what happened was Tiami LLC is this international brand which has succulents and teas, right? So what it was claiming was that if you drink our teas, everything from weight loss to migraine issues to even actually curing cancer, it was claiming all of these things without actually having any substantial proof or backing or any sort of validation behind it. Um, FTC, which is Food Trade Corporation, actually sued Tiami, saying that of course there isn't any valid proof or a very valid backing that you're doing, making these claims with. Um, Now, Tiami also, on the other hand, what it did was for its PR and marketing, it used or it hired various celebrities and various Instagram influencers to, of course, showcase their product line all over Instagram and social media. So FTC actually not only sued Tiami, It also sent legal notices to all those Instagram influencers and celebrities, telling them to first, in fact, get the background check before you start marketing for such products. So this actually was a great precedent when it came to social media advertising, where it can be anything, right? It can be any fashion brand which is now saying that now actually sustainable fashion brand, or having uh, as less carbon footprint as you want in the market. So these kind of things are very in trend right now. So um, how sustainable is the fashion brand? How will you know that? If you're the Instagram influencer, you will just get the product and market it, right? But it shouldn't be that way. Thankfully, government authorities are taking sort of a thing in this, because they don't want invalidated claims to be circulated. But yeah, there's another concept which just came to mind, which is associated with uh, sustainability, is greenwashing. So maybe you can look it up, what greenwashing means and how one can deal with it. Yeah.
So, ma'am, next question. Why
Yeah.
is trade secret not brought under the head types of IPR, and why is it designed instead?
Trade secret is not under any head, Jessica. So it's, maybe you're just confused because of the flow of the PPT, or I'm not sure why you're asking this question particularly. But trade secret is very much a part of, I would say, the contract world and not just IP. It's just that because it's your intellectual property, your way of protecting it is through the contracts, but it is not a form of design. In fact, maybe you're thinking of trade dress, if I'm not sure. Maybe you can just clarify on the question. We'll go on to the next one.
If a patent is continuously renewed year after year by MNCs, won't it amount to evergreening of patent?
No, so a patent after 20 years uh, always goes on in the public domain. That's just how it is. And if you want to still want to have protection in that patent that you are, then you will have to file another application, a fresh one. So of course, then you'll keep the timeline will keep extending that way. But all big MNCs, all big pharma companies, they keep on renewing their patents, they keep on filing fresh ones, because they know that after 20 years, the particular one that they're relying on will go on in the public domain.
Good realization of an improvisation to a patent by the patent holder, and as suggested, instead of making an amendment, filing of a new patent application not amount to evergreen of patents?
It's the same question as we just answered.
Is design always non-functional? Elements like configuration could be functional as well.
Right. So this is again one of those gray areas that we have spoken about yesterday. Um, Statutely speaking, as what is seen in the statute and the particular um, description of a design, it is supposed to be a non-functional element. Any functional aspect of it would have to be protected in some other form of IP, either a copyright or a patent or otherwise. So, if when it comes to design, it only has to be a non-functional aspect.
Do jewelry also come under fashion law ambit as to how it works and how far is it protected?
Right. So actually, jewelry, skand, is a very important part of the fashion ambit. Um, how will you protect it? Right. The brand can protect it under a trademark. The design of the jewelry will be protected. under Design Act, the image or say an element of the jewelry that you want to protect and protect under the copyright. So on and so forth. So in fact, there are lots of jewelry which are getting made right now are actually being patented because of the way they're being made. So it's very interesting time right now to see when it comes to the jewelry business.
Can traditional knowledge like Banarsi saris, which have already received a GI tag, can also be protected under design?
So when you look at see a GI is given to Banarsi saris as a whole, right? When it comes to a design application, you will have to pick a particular Banarasi sari, and that also that also apply for protection on that particular design feature. So you cannot tomorrow go and say that okay, because I have a GI on this particular Banarasi sari, it can be protected on the design, but the way you will protect it will be different.
Can packaging of a product be protected under IP?
Yes, it can be. Um, Again, something like a trade dress is not statutely covered in Indian law, but there are lots of precedents that we have seen over the years which protect packaging, which is also known as trade dress in a way, um, and it can be protected by the IP owner. So as to let the other person know that this is my kind of packaging and cannot be used by somebody else.
When someone invents vaccine for COVID-19, he or she cannot patent it, right? Like they can patent the method, but they cannot patent the product, correct?
Correct. So, when a vaccine of such for say a COVID-19 comes, we spoke about standard essential patents, right? So, say in such circumstances, a standard essential patent will be given out to the patent holder, and then they will thereafter be able to license it out to say various companies or stakeholders are in the market. So that is how it will trickle down.
Do we require a sui generis protection for traditional cultural expressions, which do play a crucial role as far as fashion industry, or whether conventional or established IP system are sufficient?
So, Tejaswini, what would you mean by cultural expressions? What do you mean by that? Could you just type that in quickly so we can answer the question?
Since we
Yes, we'll
got
go
into a
on to
lot of
the
yeah, we'll come
yeah,
to the next one.
we'll come back to this one.
Would the term wearable tech extend to the spectacles and by corollary lenses, considering lenses now consist of inbuilt insane zooming abilities?
Yes, absolutely. This is a very important facet of wearable tech. It does.
If a designer invents a new design, will she or he register it under Design Act or Copyright Act?
So, Seep, I hope you heard me in when I exhaustively explained the difference between design and copyright, and the ways that you can protect copyright and protect design. So, we'll do a quick recap. Is that if you have a new design, if say you're the designer, you have a new design line, you will the image, the sketch that you draw, the element of the particular design outfit that you make, that can be copyrighted. As opposed to if you want to copyright the entire garment as a whole, then it will have to be in a three-dimensional form. So that can be protected under Design Act. So these are the maybe one or two different ways that you can protect the same thing.
Ma'am, next question. How do we
Hmm.
differentiate between an inspired work and a copyright work? Are there any factors or tests to distinguish between them?
Right. Corsi is very interesting question. Something that I spoke for also that um, tomorrow, if you want to buy a Sabyasachi lehenga or a Manish Malhotra lehenga, you can just go to any local store and there'll be a million rip-offs. So how are you going to distinguish that mine is original, and of course the others are not? There isn't a particular test, or there isn't a particular guideline that you follow. Is just the way that if you're the owner, if you're the creator, you will have to file an application. Yes, even though if you're a creator of a copyright, it's not mandatory in India to file it. But tomorrow, if you want to stop somebody else from infringing your particular copyright, you have to have an application in it. So there isn't a laid out method. There isn't a straight jacketed answer that I can give you. It'll depend on various things. Excuse me. It'll depend on various things like you have to date back to where you got the product from, got the material from, where did you need any licenses, how much have you spent in PR and marketing. There are lots of things that you look into.
Which IP law provides protection against cultural appropriation? Is it copyrights, designs, GI, or traditional cultural expression?
Now, cultural appropriation is again. I think this question will have to be rephrased to an extent as to explain what cultural appropriation. So, Anusha, I would request you to first explain your question, then I will answer it.
Ma'am, it's 5-2 by the way. So should we take more questions or should we end it?
We can take one last one, and then we'll probably take. Tomorrow I'll try to finish my session a little early, so we can keep say like last 30 minutes for only for questions.
Sure. Can new technologies be protected by patent? If yes, why a gadget introduced by one brand after few months, other brands launch similar tech gadgets and designs?
Shubham, this is a very sweet question. Um, yes, new technologies can be patented. That is number one. What happens is that it's fairly known in the market that even though say I have a particular patent in a product, right? If I tweak some one or two claims in the say 13 claims that you've stated in your patent application, if I tweak it in some way, if I assemble it differently, if I package it in a way that the invention seems different to the patent examiner, that is how competitors actually rip technological products. This is the key way that most companies deal with it. Of course, the only way to deal with it is litigation. Tomorrow, if you see a company which is ripping off your patent claims, or if you feel that they're very deceptively similar and they shouldn't be infringing, then you file a suit against it. That's the only way to do deal with it. But yeah, this is a lot of times that I've seen myself that just changing up a few patent claims here and there, and you can change your entire application.
Ma'am, Tejaswini has replied to that question, so I'll be repeating the
Yeah,
question along with the explanation. Do we
right.
require a sui generis protection for traditional cultural expressions, which do play a crucial role as far as fashion industry, or whether conventional or established IP system are sufficient? By traditional cultural expressions, it's as in folklore, the tangible part of it, which do involve costumes.
Right. So we will have to file it under the ambit of IP itself. So, say I would, having a specific statute for traditional cultural expressions would not be as necessary, in my view, as opposed to having, say, a more in depth or more secure or tight knit statute that we already have, say, a trademark, copyright, or design. Because something like a cultural expression, say, maybe like costumes or art or design, there is a place for filing them in the in the scheme of IPR. But I would just want those particular statutes that we have to be a lot more airtight, because there are still so many ways that tomorrow you can fall into the infringement game, you can fall into the litigation game without even knowing it. So instead of having to get a new statute altogether, we can just have a more airtight one, which we already do.
So, ma'am, let's end here. We'll take the
Yeah,
rest of the questions tomorrow.
absolutely.
Uh, yeah. Thank you so much, ma'am, for such an insightful session.
My
Everyone, do
pleasure.
join us
I
tomorrow.
hope this was helpful.
Everyone, do join us tomorrow at the same time. And the link for the assignment and the feedback form shall be provided tomorrow itself. And make sure that you fill the form, and the distribution of the certificates will be subject to the fulfillment of the assignment. So, thank you, ma'am.
Thank you. Good night.